Needless to say, she maintains an incredibly busy schedule. We have been trying to get her here for some time, and we're thrilled that her schedule finally gave her the opportunity to be with us for the 3 weeks that she's able to be here as a Bach fellow. Just to get us started on the discussion, there's always a conversation about rights when we talk about what can we as advocates in the United States do to promote the Inter-American Commission on Human Rights. And one of the big issues is education about what the Commission is, what it does, what its function is, and the Inter-American system more generally. Several years ago, the Commission issued a very important report on DC's statehood. And it got a little bit of coverage in the Washington Post, which is always a big reward for advocates. But the story started with an unknown human rights organization based here in Washington, D.C. So if you could just start by telling us a little bit about the Commission, its role, its relationship to the Organization of American States and the Inter-American Court.
The Inter-American Commission is one of 2 autonomous human rights bodies within the OAS system. And along with the court, it functions as the primary human rights organs within the system. The work of the Commission is a little bit different to the court. The court's functions are adjudicative as well as providing advisory opinions, whereas the Commission's mandate is much broader, and it is also quasi-judicial, but includes the functions of monitoring the human rights situation and promoting human rights in the region. And I think a big distinction between the 2 bodies is that the Commission has jurisdiction over the 35 member states, and I say 35 and not 34 because we include Cuba as a party to the OAS Charter as one of the countries that we monitor. So we monitor every single country that is a member of the OAS, and the principle for monitoring in relation to all those states is that by ratifying the Charter, by being a part of the OAS, one has also agreed to the terms of the American Declaration on the Rights and Duties of Man. So there is a framework for thinking about rights in the Americas, which includes this declaration, but also later conventions. It's notorious that not all members of the OAS have ratified the principal convention, which is the American Convention, but the Commission nevertheless has jurisdiction over all those who are members of the OAS. And also we serve as a very important gateway to the Inter-American Court. So for the 2/3 of the states that are actually within the jurisdiction of the Inter-American Court, the Inter-American Commission sends cases to the court.
So you flagged what is often, I would say, the elephant in the room when dealing with the Inter-American system, which is the lack of ratification of the American Convention, which is the primary convention of the United States and Canada. Can you tell us a little bit what impact that has on the Commission in responding to complaints from the United States, which I know are significant, and what impact it's had on the efficacy and strength of the Commission more generally?
Well, I think the first thing to say is that not only the US and Canada fall into this category. I come from the part of the region that also has been the most delinquent, which is the Anglophone Caribbean. My state, Jamaica, has actually ratified, but most Anglophone Caribbean states in the Americas have not. We also now have the position in relation to Venezuela, which has denounced the convention. So we have a number of states in this position. I think the situation in relation to the U.S. is peculiar because the U.S. is the major funder of the work of the Commission. It is the member state that contributes the most. So it's more than ironic that it is contributing significantly to the work of the Commission, but hasn't acceded to the full panoply of rules and principles that apply to member states. I think you see some clear moments where the difference between ratifying states and non-ratifying states is evident. You see it in the response to precautionary measures, which is a very distinctly Latin American concept. I think for Anglo-Americans, we would probably talk about injunctions. but with precautionary measures which are really designed to provide immediate protection in cases of urgency and immediacy. The response of the United States to the measures granted by the Commission has been exceptionally poor, and specifically in death penalty cases. There are virtually no cases where the Inter-American Commission has asked the United States not to execute while it hears a matter or petition before them where it has done so. And many notorious incidents in which executions have taken place notwithstanding. I think the other place where you see a strong discrepancy between ratifying and non-ratifying states is in relation to the friendly settlement procedure. Now, the friendly settlement procedure is discussed very explicitly in the American Convention, and the US and Canada are not ratifiers of that convention, but nevertheless, the mechanism still exists as another way of trying to think through resolving serious human rights issues, and it is very noticeable the difference between ratifying and non-ratifying states in taking advantage of those mechanisms. There was an indication from the United States in a very important case relating to Guantanamo Bay of its willingness to engage in a friendly settlement procedure. However, that never led to any friendly settlement. And in fact, that person has been repatriated in conditions which were of concern to the Commission, to his home state from Guantanamo Bay.
So the issue of the death penalty flags for me another issue that comes up often, particularly in the context of the United States, but I'm sure it comes up in other countries, and I'm curious how it plays out in the issue of federalism. So when advocates raise with the State Department questions of implementation of Commission decisions and other human rights advocacy, so many of the rights violations that are being raised, such as the death penalty, are being carried out at the state level. And the United States says, well, this is an issue of federalism, and we call the Attorney General of Texas, and the Attorney General of Texas says, well, what state are you calling from? And so there's this real lack of understanding between the states and the federal government about what potential obligations they have on human rights. And I'm curious how that's played out in other countries.
So the U.S. is not the only federal state, but we certainly hear, and we hear concerns about federalism, or the Commission routinely hears concerns about federalism from other states, but not with the frequency and the insistence that we do in relation to the United States. So I think of Mexico, for instance. It's now routine for the Mexican state to ask state officials to be present in hearings and in proceedings so that they can also answer to matters which fall within the state's jurisdiction. So it's not an insurmountable hurdle. And I think, ironically, we had a hearing in relation to Puerto Rico. The Commission, and please forgive me for saying we, I'm adjusting to the fact that I'm not part of the we anymore, but the Commission had a hearing in relation to Puerto Rico in 2015 or 14. I'm not sure, I don't remember the exact time. After a long period with no hearings in relation to Puerto Rico, which is often invisible because of the existing colonial arrangement. And the officials from the Puerto Rico government were asked by the State Department to be present, and they were. Setting, I think, a great precedent for how the United States should respond in relation to other matters where there are questions of federal jurisdiction, which is to ask the relevant officials to fully participate and to be present, but it's a signal of the different relationship with Puerto Rico that it asked, and those officials were present and fully represented. And interestingly, one of their concerns, very pointedly, was about the death penalty. And their concern was that notwithstanding the decision of Puerto Rico to abolish the death penalty and to constitutionalize that position, it was still being subjected to the federal death penalty. And it made a very pointed comment to the federal officials present about that anomaly, which placed them in a position where they found themselves being less respectful of human rights than they would want to be. So I think it's not insurmountable. I think state officials can be invited to the table and encouraged, and certainly in the context of the very important case of Jessica Lenihan, a lot of the work which we tried to do in seeking the full implementation of the recommendations made by the Commission in that merits reports, just to say Jessica Lenihan was a Colorado woman who had a protection order against her husband who was estranged from her. And it also applied to her children. He kidnapped her children. She sought the help of the police in finding him and securing the safety of her children. She did so repeatedly. They said to her, effectively, why are you bothering us in a domestic problem? You should have sorted out these issues. Her children were found hours later dead in the back of her husband's car. And the U.S. Supreme Court had a very different way of thinking about the responsibility of the state. The Inter-American Commission found that the United States had failed to observe due diligence in preventing the violence and protecting Jessica Lenihan and her children. And here we see an instance in which the Inter-American Commission and the petitioners tried very hard to encourage the United States to bring the state of Colorado to the table, to find ways in which Colorado could be engaged. And I think the work by U.S. NGOs and clinics in relation to the Lenihan case also shows us some way forwards, because the way forward in some cases is in the United States, because a number of legislative bodies passed resolutions throughout the United States. So even though Colorado itself hasn't been responsive, we've seen other states responding in other ways to the Lenihan case in signaling that we understand the norms articulated by the Inter-American Commission as ones which are important ones for us to observe in the United States and in our states.
Since you mentioned the Lenihan case and the role of the lawyers, what have you seen as the role that lawyers in civil society are playing in the commission? Has that evolved, and is there a role that we should be playing that we aren't playing?
I mean, I think more than anything else, civil society, and I would add victims. And it's interesting because in the Inter-American system, the terminology victims doesn't have the kind of stigma which it has in other spheres. It's actually a space of empowerment historically in the Inter-American system. Both civil society and victims have helped to shape and change the agenda of the Inter-American Commission, to determine the priorities of interest in a given moment, to figure out where the Commission has to devote more resources, to determine where the Commission does its on-site visits, in other words, places where it has the greatest concern. Now, not only civil society helps to shape the agenda, but it's certainly an important part of it. And I think two significant processes support that. One is the petitions which are filed. The petitions which are filed, including some which have been filed by your clinic, have been instrumental in focusing the attention of the Commission on specific issues. I think the work, for example, of the coalition of actors involved with the Inter-American system in the United States has helped to focus the attention of the Commission on human rights violations by the United States. And that's been very important. And so even though, and I think to respond to an earlier question, even though the United States hasn't ratified the American Convention, it is one of the most monitored states using every other mechanism available to the Inter-American Commission. So there are almost as many hearings from the United States, related to the United States, as any other country. Probably it's in the top 2 or 3 countries where we have significant hearings every period of sessions. And although we don't have a wide variety of petitions, commissioners have taken advantage of the presence of the commission in headquarters in the United States to conduct fact-finding visits, for example, on race and criminal justice, juvenile detention, a range of very pertinent issues today.
So I'm curious, I mentioned in your introduction that you held the post as the first special rapporteur on LGBT rights. How did that rapporteurship come about? And what do you see as its role in the region?
I think the way of thinking about the rapporteurship, and there's a distinction in the inter-American system which can feel imperceptible, but for the commissioners, it's very perceptible between a rapporteur and a special one. So in fact, this one isn't a special rapporteurship. Freedom of expression is a special rapporteurship, and it is hoped that the unit on economic, social, and cultural rights will evolve into a special rapporteurship. The difference is rapporteurships are headed by commissioners, and special rapporteurships are headed by full-time professionals who focus all of their energies and that of their staff on that thematic issue. I think the work on LGBTI issue, which preceded me at the Inter-American Commission, started with the establishment of a unit at the end of 2011. So by the time I came to the Commission in the beginning of 2012, there was already an institutional framework. And that institutional framework was certainly partly in response to the activism and the actions in the General Assembly of the OAS, which since 2008 had historically passed a resolution every single year on the rights of LGBTI persons. And that process continued unabated until about 2013, where we began to see some pushback. So in an interesting way, the political processes started and energized the OAS and one of its principal human rights bodies to undertake specialized work in relation to LGBTI persons. And if you think about 2012, when the unit starts its work, it is also a period in which the Inter-American Court decides the case of Karen Atala, a Chilean judge who was denied custody of her daughters because she was lesbian. And post-divorce, she had custody, but once it was discerned that she was in a relationship with a woman, the courts denied her custody and transferred custody to her husband. That emblematic case also gave impetus and a juridical basis for the work of the Inter-American Commission. And within the course of a year and a half, the Commission translated what was a unit with a focus on LGBTI issues. In other words, very much inspired by the work in the political bodies, but also civil society, which had lobbied the OAS vigorously over a period of years. And I would have to say, having spent 4 years at the Inter-American Commission, it is the only grouping of civil society that includes, in a meaningful way, the Caribbean civil society actors. And so I think that both civil society, which has a coalition across Latin America and the Caribbean, the body of resolutions, the Atala case, provided a framework for the ramping up of the unit to a rapporteurship at the end of 2013, which is what happened. So, I became the first rapporteur because I was a commissioner in charge of the unit, which I assumed sometime during the course of my first year.